Welcome to another episode of OTM the Podcast. I am Ed and Zombie, your host, and today we have another special guest, Steve Shane. Steve is an estate planning attorney with the law firm Offit Kurman. He provides strategic counseling to clients in need of estate administration, charitable giving, and nonprofit business creation and planning. In addition, Steve provides legal guidance for gifting and generation skipping tax exposure. So, when we say estate planning, what comes to mind for me anyway is impactful legacy in terms of wealth management and education about wills, trusts, and so forth. But without further ado, please join me in welcoming Steve Shane. Welcome, Steve.
Thank you, Ed. Glad to be here.
Outstanding. I appreciate you really taking the time out to come have a conversation with me that I think our audience will find very interesting and probably educational to a degree. With that said, the audience members, if you have comments or thoughts, please don't hesitate to put it down in the comments section of the channel. What we'll do is Steve and I will probably return at some point here and actually answer any questions that you have. So, Steve, let's start with protecting legacy. Will and trusts, what are they and how can we use them?
That's a good question, Ed. So everybody needs an estate plan because everybody at some point in their life is likely going to die. As much as we don't want to think about it, it's a reality. So I always tell clients it's better to plan when times are good because it's difficult when you start planning when there's a crisis or a problem. It's much more difficult to do things. And so, if you plan while things are good, you have a clear mind and it tends to be easier. You're not trying to force anything. You just sort of, you have time and time is on your side and you come up with a plan. There's lots of ways to plan. I like to come up with the plan and then we document the plan. So you could have a will, you could have a trust, you could have payable on death designations. There are a lot of ways to document a plan, but I guess you need a plan. So the first step is to have a plan.
I like that. That's a great point. So, what's the difference between a will and a trust?
Okay. Well, most people know what a will is, but a will is just a document where you leave which basically is a set of instructions where you want to leave your property upon your death. In a will, you appoint typically an executor, or in Maryland, we call an executor a personal representative, but it's the same thing. And you essentially have a set of instructions to the personal representative as to how to dispose of your assets upon your death. You can do the same thing in a trust, but there's many different varieties of a trust. Primarily in the estate planning world, a trust will have certain benefits. One primary benefit is to avoid probate. So if your assets are in a trust, namely called a revocable living trust, upon your passing, it bypasses the probate process, which I guess leads us to the next question of what is probate. But a trust has many benefits, and there's, as I said, not to be repetitive, but there's lots of varieties of trusts, and they can accomplish different goals. Tax mitigation, probate mitigation, asset protection, dispositive, distribution. There's marital trusts, there's all kinds of trusts. So it's hard to just say what a trust is. Last thing I'll say about it is if you basically get down to the bare bones as to what is a trust is really just an agreement or a contract where a person will say, I am going to leave assets in trust for the benefit of a person. So I could leave assets for the benefit of Ed, and I could have someone else be a trustee. And it's just an agreement that you have to manage property for the benefit of a person. And that's really all a trust comes down to.
Got it. I think one of the questions that is commonly asked is, are wills and trusts only for the wealthy or those that have assets? What are your thoughts about that?
No, I don't think trust is only for the wealthy. As I said, there's different benefits. So it really depends on what your goal is. If your goal is probate avoidance, whether you have $1 million, 100 million, or 100,000, that's still your goal. And a trust can get you to that goal. If you have your assets in the trust, you could avoid probate. There is sort of a connotation out there where trusts are for the very wealthy. And there are some trusts, and wealthy people do put their assets in trust for a variety of reasons, namely for tax mitigation purposes and to keep assets better protected for their family. But I would say as a general rule, no, it really is, they're not just for the wealthy. It can be for anybody that has a certain goal, and trusts can help meet that goal.
So let's go back to a point that you were making because you used the word a couple of times. How would you see probate being useful? And is there an example of where there was no probate protection, if you will? And, what does that look like in terms of possible outcomes?
Yeah, well, most people, or a lot of people would like to avoid probate. Look, it doesn't help the person who sets up the trust potentially because they won't be around, but it's for their children, say. Um, and if you have an asset that would otherwise be included in your estate for probate purposes, take a piece of real estate, take a brokerage account, take a bank account. Um, if you retitle that asset, you're going to avoid that process. Now, what is probate? Well, probate is a court administered process of selling one's estate or selling one's affairs. There are delays that are associated with probate. There are costs associated with probate. There's oftentimes court costs. There's attorney's fees. There's personal representative commissions. Appraisal costs. There's things that go into that process. So all things being equal, if you can avoid it with a trust or anything else, tends to be a good idea.
So those costs that you gave examples for are actually incurred by whomever is left behind, in other words.
Yeah, it's a cost of the estate, but who is the estate benefit? Well, it benefits the children, say. So it tends to come out of their pocket, even though the costs are incurred by the actual estate. But who are the beneficiaries of the estate? So it's really the same thing. And delays, it can take up to a year. We've administered estates that take 2 years or 3 years, and it just really depends on how complicated the assets are, whether there's conflict within the family, whether there's business interests that, maybe have different opinions as to the value. So you want those set of instructions, whether it's a will or a trust, to be clear. That's probably one of the more important points of all this, is that you really need to make it clear. You don't want to end up in a court situation or a court battle with your siblings. And so if you start with the notion that we want a clear set of instructions in a will or a trust, you can get to the same place, but why not have a trust that would then avoid the need to probate these assets and go through that process? Trusts are much more confidential in nature than a will, because there is no public process. It's a private process.
So I'm going to back into my next question because I think you'll answer it in terms of who do you see setting up wills and trusts? And is there like an age that you see people begin to actually put it in place versus just being aware that these things exist and are optional?
Right. So typically I see the first time a client wants to do an estate plan, I'll call it an estate plan, but it could be a will or trust. But a plan is when usually they get married and have kids. There's a need for that because they want to appoint a guardian for their minor children. They want to make sure that the assets are in a trust or something that, some way that it's protected for those kids. They want to appoint an executor. They have assets. So if you have assets, then you probably need some sort of estate plan.
And assets could be a house, could be a car.
Could be a house, could be a car, could be stocks and bonds, personal items, whatever that might be. And that's usually the first time people will come in to do a will. When they have kids, they start to have assets, they're accumulating some wealth. Then, things happen and maybe their kids are older now and they come back and they need to modify things. Well, we don't need a guardian anymore. The kids are all adults. We probably don't need to set up some sort of protected mechanism for those assets because now we trust our kids. Sometimes we don't, but presumably they do. And then we want to change things. Maybe the next time will be they have grandkids and they want to sort of change up the beneficiaries and they say, well, now we want to leave some to our grandkids, or we have some charitable beneficiaries that we have in mind. And that's sort of the second stage. The last stage tends to be, well, now, we have other goals. We want to, maybe do some tax planning because maybe their wealth has grown over the years. So it's time to do some tax planning. Or, we don't really like our son's wife and we have concerns that we don't want to leave these assets to my son and have them get divorced in the future. So what can we do to prevent that from happening? We've been working with this nonprofit that we really like, and now we want to leave some money to them. So, as life goes on and things evolve, I think people have different goals, and depending on where they are, what station they are in their life.
Now, I appreciate you going through the general, there were actual seasons or brackets that we really clearly find. This is probably a good segue to let our audience know that you certainly want to seek legal counsel. This is not a legal counsel situation. It's a conversation about what perhaps I've heard or what Steve commonly hears in his profession in terms of things around wills and trusts. So please seek legal counsel, but certainly I think Steve did a great job of panning out some really milestones in life that come out in terms of when people decide to think about wills and trusts. With that said, I don't think you covered what happens if you don't have a will or a trust and you get into a probate situation. Can you give us an example of what probate looks like in terms of this could have been avoided had we put these things in place?
Sure. So two things. One, if you don't have a will, you do have a will, but it's the will that the state of that you reside in writes for you. So if you don't have a will, it means you die intestate. And what that means is that the state that you reside, Maryland or whatever state it is, has written a will for you. It's just a statutory will, and it directs where your assets are going to go. It may not be where you want them to go. So just because you don't have a will doesn't mean you don't have a will. It just means you may not have the will that you want. So that's the first point. The second point is that what does probate look like is really your question, I think. Probate is not the be-all, end-all. There is a process, and that is called probate, where essentially the court of the applicable jurisdiction just wants to make sure those assets go to where they're supposed to go. And in order to do that, there is, can be a substantial amount of paperwork involved, meaning the executor has to be formally appointed. The executor has to formally value the assets. The executor has to sign off on tax liabilities. The executor has to make sure that any debts outstanding are dealt with appropriately. Since, if John Smith owes somebody money, well, John Smith's going to want to make sure that John Smith gets paid, and it's the executor's role to make sure John Smith doesn't get left holding the bag. And so there's a process in that. There's also a process of accounting to account for every penny that is under the executor's control from the time that that person is appointed to the time that the estate is closed. And you get a closing letter from the court, and the court blesses and says, you've done everything right, we approve it, and now you're able to distribute. And who are the beneficiaries that you can distribute to? Whoever is named in the will. Or, if there is a will, if it's not a will, then whoever the state of Maryland, in this case, determines who gets that property. And that's the probate process. It's not always bad. I mean, in some cases, some people want that court oversight. They want to know that somebody is looking over the shoulders of whoever is the executor or whoever is the administrator to make sure those assets are properly distributed. But so I guess it's the question how much that could cost, or is the question?
Well, I think you're actually touching it, and that's why I gave you a lot of leeway, Steve, because
I never get a short answer with it.
no, I think your answers are succinct, and I like that. But I like the fact that you are actually being preemptive in some of the things that happen, and I think it's better if you tell it than me guessing as to, well, what happens, and you're like, well, there's a segue here that you may want to think about.
Right.
This can be costly, and I'm like, I wasn't necessarily going to ask cost, but I certainly was looking at the challenges that you've already mentioned, which is coordination with family and loved ones in terms of if you don't have it prepared, you really don't know what to do with assets or what the person's will, which is sometimes not always assets. It could be other direction that is just not documented, and people don't know what the family man would want it done about a situation, or literally some assets is most commonly the case in wills. But yeah, I'm going to give you lots of latitude because I think you're doing a great job of covering questions that our audience may have that I'm not thinking of. But along those lines, then, I think just to wrap up will and trust, it sounds like the courts are involved either way. If you don't have a will and trust, there is a will that is executed on your behalf by the state, if I understood correctly.
It's not a will that's executed. It's a statutory directive as to where those assets go, because if there's no will, then but for a statute, who knows where those would go? So the state would determine, okay, well, do you have a spouse? Do you have children? Here's the allocation between the two. And that may not be what you want. You may say, well, I wanted everything to go to my spouse. Well, you can't have that because you didn't have a will, and the statute says those assets go to your kids, or they're split 50-50 between your kids, or they're split a third to your spouse and 2/3 to your kids. So generally they would go to those people, but maybe not in the allocation that you want.
Yeah.
Anyway, so I think I got a little off track with the probate again, if you want to bring it back to that.
Sure. I mean, I was just looking at what could be a bad repercussion of not having probate.
Yeah,
It sounds like it's still somewhat structured, even though there is probate, right?
Yeah, I mean, probate is a more structured process. And for people who are coming in or want to do some planning, since there's a cost associated with probate, many people say, well, I don't want my kids to have to endure that cost. That's a cost that comes out of their pocket eventually. So let's structure the assets in a trust or some other way to avoid that. And it can be done, but you just have to plan for that. And one of the ways to plan is perhaps through a trust.
Absolutely. So just to kind of put a caption on that, the process of planning is something that I think some may be reluctant to think forward. But I guess growing up and hearing stories of famous people that didn't have a will or a trust, and even family members that were struggling to gather funds to bury their loved ones, it's like the planning was there, but there's also the financial. That I don't think the will, or does the will and trust a lot for financials? How does the financial cost of burial, et cetera, perhaps insurance, play into what is written into the will or the trust?
Well, once call it the executor is appointed, the executor would have generally access to whatever estate assets there are and can use those to pay for funeral expenses, can pay for accounting fees, some of the costs associated with, winding up somebody's affairs. But it doesn't always mean that the executor does have money, because sometimes, if accounts are joint, they pass to a joint owner, or if they're beneficiary controlled, they pass to that named beneficiary. So you could get in a situation that the executor is appointed but has no access to funds because the funds were already dispersed pursuant to a payable on death account or a beneficiary account or a life insurance policy that just simply named somebody else. So it is important to be careful and understand the asset flows, meaning what is the asset and how is it directed? Is it distributed because it has a beneficiary attached? Is there another person on the account that would just take over that account? Or would it indeed pass to the executor so the executor has these funds? So, we've had a number of situations where you can call it maybe a perfect plan because there's no probate, but then there's no one to step up and pay for all these costs because everything was just automatically dispersed. And if the executor has no access to funds, could be a contentious situation. Most people don't want to come out of pocket if they don't have to. And, it can get, it can be difficult. So the bottom line is always, try to seek some assistance if you can, but plan in such a way that makes sense. If you want to avoid probate, that's great. That's a great goal. But how are we going to do that? And what are the assets that we have to plan for or plan with? And maybe there's a medium or a happy medium where certain assets are automatically dispersed. Certain assets are in the control of what I'll call a fiduciary. Could be an executor or a trustee, somebody who has control, and then leave them instructions as to what to do with that money. And it's just about intent. What is the person's intent and what's their goal? If their goal is to avoid probate, then we should be able to get them there. If their goal is to, protect the assets, then how do we do that? What's the best way to plan for that? So a lot of it is just dependent on the situation.